Engine off. Hands on the wheel. Now.
Officer, listen, my daughter can't breathe. We need the hospital now.
Step out of the vehicle. ID in hand. Do it now.
Look at her. She's dying. I'm a judge. Verify me and escort us.
I said turn around. Don't argue with me.
If you do this, she won't make it. You're killing her.
Cuff.
The sirens were on, but they weren't loud enough to cut through assumption. At 2:17 a.m., a black sedan raced down a rain-glossed interstate, hazard lights flickering like a pulse about to fail. Inside the car, a teenage girl struggled for air. Behind the wheel, her father, an appellate judge sworn to uphold the law, was counting breaths, not miles. When red and blue lights flooded the rearview mirror, no one yet knew that a routine traffic stop was about to become a fatal intersection of power, bias, and irreversible silence. If you believe stories like this matter, not as outrage, but as warning, stay with us. Watch closely. Because what unfolds isn't just about one stop or one officer. It's about how systems fail when urgency meets disbelief. The night didn't announce itself as dangerous. It arrived the way most nights do: quiet, routine, unremarkable. The highway outside Atlanta lay open and dark, asphalt still damp from an earlier drizzle. Streetlights stretching into long amber reflection. Inside the black sedan, the dashboard clock glowed 2:09 a.m. The radio was off. No music, just breathing. At first it was easy to mistake the sound for nerves. A shallow inhale, a pause too long, another breath that didn't quite finish. "Slow it down," he said gently, eyes flicking between the road and the passenger seat. "In through your nose, out through your mouth." His voice carried the calm of a man trained to speak when others panic. Years on the bench had taught him how to steady rooms full of shouting attorneys with nothing but tone. Tonight, that tone wavered just slightly at the edges. She nodded but didn't answer. Her hands were clenched in the fabric of her hoodie, knuckles pale, shoulder hunched as if bracing against something invisible pressing inward. The smell inside the car was faintly medicinal antacids, the kind you keep in the glove compartment and hope you never need. "Dad," she whispered. "I can't. It feels tight." He reached over at the next red light, placing 2 fingers against her wrist. Too fast. Not chaotic, but urgent. The kind of rhythm that told him this wasn't anxiety. It was physiology. He considered calling 911. He even lifted the phone. But he also knew the response times at that hour. The way dispatch triage calls, the minutes lost to routing, staging, transfer. He had presided over cases involving emergency response delays. He knew how quickly help is on the way could stretch into something else entirely. The hospital was 12 minutes away. "Okay," he said, decision settling in his chest like a weight. "We're going now." The car eased onto the interstate. He accelerated past the speed limit, not recklessly, but deliberately, hazard lights blinking in steady intervals. Georgia law allowed it. Emergency doctrine, necessity defense. He had written opinions that referenced it. A reasonable deviation from traffic code to prevent imminent harm. He wasn't thinking like a judge, though. He was thinking like a father counting breaths. 5 minutes in, her breathing changed. Not faster, thinner, like air moving through a narrowing space. "That's it," he murmured, pressing harder on the gas. "Stay with me." Red and blue light bloomed behind them without warning, washing the interior in color. The reflection cut across the windshield like a blade. He sighed, not in frustration, but calculation, and eased onto the shoulder. Gravel popped under the tires. He kept the engine running. The patrol car stopped at an angle, just as the manual instructed. Offset. Dominant. Scene control. The officer approached slowly, hand near his belt, flashlight slicing through the darkness. Standard traffic stop posture. Command, presence. "Turn off the engine." "I can't." The judge replied immediately, window already down. "My daughter's having trouble breathing. We're headed to Grady." "I'm an appellate. Turn off the engine." The words were clipped, practiced, the kind used to establish hierarchy before conversation. He complied, hands visible on the wheel. The hazard lights died with the engine, plunging the car into relative darkness except for the cruiser's strobes. "My daughter needs medical attention now," he said carefully. "She's hypoxic. You can call it in. I'm authorized under emergency." The flashlight moved past his face, landing on the passenger seat. On her, folded inward, lips tinged faintly blue. "What's your name?" the officer asked. He gave it. Then, instinctively, he added the title, not as a shield but as shorthand. A way to compress explanation. The officer's jaw tightened. "Step out of the vehicle, please," he said, and the word surprised even him. "Just escort us. She's deteriorating." The pause that followed wasn't dramatic. It was procedural. A few seconds stretched long enough for doubt to form. You got proof of who you say you are. He reached slowly for his wallet, narrating each movement the way he'd seen defendants coached to do. The badge was there. The ID issued by the state. Laminated authority. The officer glanced at it once. Then again. Huh, he said. Looks fake. It isn't, the judge replied, still calm. You can verify it through dispatch. Call my chambers, please. Behind them, her breathing stuttered. A soft sound. Almost a cough. Almost nothing. Step out of the car. Now. Training dictated escalation when compliance wavered. The manual didn't include oxygen saturation levels or the sound of a child struggling to breathe. He stepped out. Cold air hit his face. The shoulder smelled of wet earth and exhaust. The cruiser's lights pulsed against his chest, against the badge still visible in his hand. Turn around. This is a mistake, he said quietly. The cuffs closed with a clean, efficient click. Inside the locked car, the air grew thinner. Silence filled the space where sirens should have been. After about 600 words, the night still hadn't ended. It had only made its choice. The back seat of the patrol car smelled like disinfectant, old vinyl. The door closed with a hollow thud that felt louder than it should have, sealing him into a narrow space where the world became filtered through glass, through procedure, through someone else's authority. The engine idled, a low, constant hum. Sir, sit back, the officer said, already turning away. I need you to check on my daughter, he replied, voice steady but pitched carefully above the noise. She's in respiratory distress. You can see it. The officer didn't answer. He walked back toward the cruiser, radio crackling to life at his shoulder. Dispatch, I've got one detained for reckless driving. Possible impersonation. Requesting verification. Impersonation. The word landed heavier than the cuffs. From the back seat, the judge twisted as far as the restraints allowed, straining to see through the windshield. His car sat ahead, dark and still. No hazard lights now. No movement inside that he could see. He began counting again. Not seconds. Breaths. 1, 2. The cruiser's radio chirped. Another voice, flat and distant, reading from a screen somewhere miles away. Copy. Stand by for confirmation. Stand by. That phrase had weight in courtrooms. It meant pause, delay, time to think. Tonight it meant something else entirely. He leaned forward, pressing his forehead briefly against the partition. Officer, he called out, louder now. I need EMs. Now. She's cyanotic. The officer returned to the open door, posture rigid, flashlight angled down instead of at his face. You should have thought of that before speeding, he said. That's not what this is, the judge replied. You know emergency doctrine. Georgia Code Section 40 to 6-6. You can escort us. You're trained for this. A flicker crossed the officer's expression, not uncertainty, but resistance. The kind that came when a situation threatened to slip out of the narrow lanes training provided. Sit tight, he said. We're sorting it out. Sorting it out. The cruiser door closed again. Time didn't move normally after that. It stretched and folded back on itself, broken into fragments by radio static and the distant rush of passing cars. Each vehicle that roared by felt like an accusation motion where there should have been urgency. He watched the officer confer with another patrol unit that had arrived. Silently, blue lights washing over the scene without sirens. A supervisor, maybe. The chain of command asserting itself inside his chest. Panic tried to rise. He pressed it down with habit. Panic never helped anyone think. Panic never won cases. But this wasn't a case. He raised his cuffed hands as high as he could, banging once against the glass, not violently, just enough to be heard. My daughter is dying, he said. The sentence came out flat, stripped of drama, a statement of fact. The supervisor glanced briefly toward the sedan. Then back to the officer. Did you search the vehicle? Not yet. Do it. No one opened the passenger door. No one checked her pulse. They were still deciding what he was. Dispatch crackled again. Subject's name does come back as affiliated with the judiciary, but credentials need visual confirmation by supervisor. Affiliated. The judge closed his eyes. The word reduced decades of service to an asterisk. A paramedic unit was requested then, not as an emergency, but as a precaution. The difference lived in the tone of the radio call. No urgency code. No lights requested. He felt it before he saw it, the change in the air. The intuition every parent develops without ever wanting to. The absence of sound from the car ahead. No shifting. No breath fogging the glass. Please, he said again and quieter now. Please. When the paramedics arrived, They moved briskly but not fast. Gloves snapped on. A stretcher rolled out. The passenger door finally opened. One of them froze. "Hey," she said softly, to no one in particular. "She's unresponsive." The words hit like cold water. Hands moved faster then. Oxygen. A bag valve mask. Command sharpened. "What's the downtime?" No one answered. They worked in the beam of the cruiser's lights, shadows jumping across the pavement. The judge watched through glass thick enough to feel like a wall pulse. Someone asked. A pause. Too long. The supervisor shifted his weight, eyes forward, jaw set. At 2:41 a.m., a paramedic stepped back. "She's gone." The radio went quiet. Even the highway seemed to pull away, traffic thinning as if the night itself had decided to look elsewhere. No one spoke to him at first. The officer finally opened the cruiser door, hesitation creeping in for the first time. "Sir," he didn't answer. He was staring at the open car door, at the stillness where motion had been. In that moment, something fundamental broke, not loudly, not visibly. Just a quiet understanding settling in. The law would not save him tonight. Forms appeared. A clipboard. Names, times, checkboxes. A white sheet was drawn up. A zipper followed, its sound precise and final. The body bag closed while pens kept moving. Paperwork continued. After about 600 words, the night still wasn't finished with him. Grief didn't arrive like a wave, it hardened. In the days after, the world continued at a pace that felt almost insulting. Courthouses opened on time. Dockets were called. Patrol shifts rotated. Somewhere, a clerk stamped a form with the same dull thud it had always made. The judge did not return to the bench. Administrative leave was automatic in cases involving immediate family loss. Standard protocol, neutral language. A memo from the Judicial Qualifications Commission expressed condolences in careful, symmetrical sentences. He read it once, folded it, and placed it in a drawer he did not open again. At the police department, another machine turned on just as smoothly. Internal Affairs logged the incident within hours. Case number assigned. Evidence preservation order issued. Body cam footage was uploaded to a secure server, tagged, time-stamped, checksum verified. No one edited it. No one needed to. Policy required preservation, not interpretation. The officer was placed on paid administrative leave, also automatic, not punishment, not vindication, just distance. A supervisor signed the form with a pen that had done this many times before. In a small, windowless room, statements were taken. The officer spoke first. His voice was steady, professional. He used words like non-compliant, scene safety, uncertain credentials. He described the judge's tone as agitated, the situation as fluid. He emphasized training, officer safety, chain of command. He did not mention the color of the man he arrested. He didn't have to. Another officer corroborated, not perfectly, just enough. When it was the judge's turn, he declined to elaborate. He provided dates, times, statutes. He referenced Georgia's emergency doctrine the way he always had in writing, in precedent, in fact. He did not raise his voice. He did not speculate about intent. Everything he needed to say already existed. The footage was reviewed quietly at first. Command staff, legal counsel, risk management. The room stayed dark, illuminated only by the glow of the screen. The video did not blink. It showed hazard lights, a calm voice, a badge held steady, not waved. It showed a girl in a hoodie folded inward, her chest barely moving. It showed an officer's flashlight pause on her face and move away. It showed time passing. Use of discretion standards were discussed in low voices. Training modules were cited. Officers were taught that emergency exceptions existed, but also that impersonation was a known risk, that criminals used props, that hesitation could get you killed. The training never said this explicitly, but everyone in the room understood the subtext. Discretion was allowed. Trust was optional. Race was never mentioned in the room either. It hovered instead, uninvited, like a variable no one wanted to name, but everyone could see influencing the equation. Outside, the story didn't explode. It accumulated. A local reporter obtained the incident log through an open records request. The timestamps didn't line up the way they should have. A legal blogger noticed first, posting a thread that asked quiet questions instead of making loud accusations. Why no EMS code upgrade? Why no escort? Why the delay after visible distress? A week later, the bodycam footage was released under public pressure, not leaked. Not sensationalized, just posted, raw and unscored, exactly as policy required. Once a death occurred in custody-adjacent circumstances, the public watched. They didn't argue about what they saw. They replayed it. The comments didn't surge with outrage. They hardened into something more dangerous for institutions' consensus. Civil rights attorneys began to circle, not theatrically, but methodically. They pulled training manuals, they cited case law. They highlighted the gap between policy and practice, between what discretion allowed and who it trusted. The department issued a statement. We are reviewing the incident thoroughly. It said nothing wrong. It said nothing useful. Inside the judge's house, silence became routine. The bedroom door stayed closed. Her shoes remained by the door where she'd left them. He did not move them. When prosecutors announced their decision, it came in a press conference with no raised voices. There would be no criminal charges. The standard was high. Intent was hard to prove. The officer had followed procedure mostly, but the district attorney added something else, almost as an aside. There will be a civil review. The room shifted at that. Civil meant records, depositions, emails, training histories. Civil meant discovery. It meant the story wouldn't stay narrow. It meant reckoning without sirens. The judge watched the announcement from home, standing, not sitting. He turned the television off before questions began. For the first time since that night, something changed, not inside him, but around him. The system that had closed ranks began slowly to open files. Tragedy had been documented. Now it was being examined. The camera didn't fade out yet. It held the frame, steady and unblinking, as the story prepared to move from aftermath to consequence. The courtroom was quieter than the highway had been, but the silence carried more weight. No sirens, no flashing lights, just wood, glass, and the soft shuffle of paper as attorneys rose and sat with practiced restraint. The seal of the court hung behind the bench, familiar to the judge now, in a way it had never been before. This time, it wasn't his authority it represented. It was distance. Language sharpened here. Words were chosen not for command, but for permanence. The civil trial moved without spectacle, no raised voices, no dramatic pauses. The facts didn't require them. An emergency medicine specialist testified first, speaking in measured tones about hypoxia, how oxygen deprivation narrows the margin between distress and death faster than most people understand. He walked the jury through timelines using nothing more than physiology and clocks. After 3 to 4 minutes, he said, pointing to a diagram of lungs, brain injury becomes likely. After 6, survival drops precipitously without immediate intervention. He didn't look at the officer when he said it. He didn't need to. Next came a former police training supervisor from a neighboring state. He spoke about discretionary authority, about how recruits were taught to balance officer safety with situational awareness. He acknowledged the manuals. He acknowledged the checklists. Then he paused. Training, he said, teaches control. It does not always teach context. The officer sat straight-backed at the defense table, hands folded. He had been advised not to react. He followed that advice well. In his deposition, played on a large screen, he appeared smaller than he had on the roadside, less certain. The questions were calm, surgical. Did you believe the subjects? Credentials were fake. Yes. Why? I've seen impersonations before. Did you verify through dispatch before detaining him? No. Did you observe the passenger's condition? Yes. And you still chose not to expedite medical aid? A pause, longer than before. I followed procedure. The answer wasn't defiant. It was honest. That honesty cut deeper than denial would have. Emails surfaced. Training updates circulated months before the incident, emphasizing bias interruption and emergency overrides. Attendance log showed he had missed the session due to staffing shortages. No violation, just absence. The system had not failed loudly. It had failed quietly. Through gaps no one was tasked with closing. The dollar amount entered the conversation late and carefully. Attorneys didn't argue it as compensation. They argued it as consequence, as deterrent, as a signal the institution would understand. $45 million, not for pain, not for grief. For loss quantified in a language institutions respected. When the verdict came, there was no gasp, no visible reaction from the gallery. The jury foreperson read the decision with a steady voice that trembled only at the end. Liability was found. The department was ordered to pay. Policy failures were named. Training deficiencies documented. Oversight criticized without cruelty. The officer was not personally bankrupted. The system absorbed the cost, but accountability, uneven as it often was, had found a place to land. In the hallway afterward, the officer stood alone, staring at the floor. His attorney spoke quietly beside him, words blurring into administrative noise. Termination papers arrived 3 weeks later, delivered in a plain envelope. No ceremony, no press. The letter cited conduct unbecoming, failure to exercise discretion, violation of duty of care. Years of service reduced to paragraphs. He read it twice, signed where indicated, turned in his badge without argument. Outside, the building looked the same as it always had. Brick, glass, flags unmoving in still air. Certainty had carried him that night. Certainty had told him control was safety. That doubt was weakness, that procedure was protection. It had cost him everything he was trained to value. Inside the courthouse, the judge walked past a courtroom for the first time since the verdict. He did not go in. He did not need to. Justice, he had learned, did not feel like victory. It felt like weight redistributed, never removed. The system had spoken. Now it would have to change. Change never arrives with the way people expect. It comes in memos, in revised language, in meetings that start on time and end with action items no one applauds. 3 months after the verdict, the department issued its first directive. It wasn't framed as an apology. It didn't mention names. It was written in the neutral dialect institutions prefer when they are trying to survive scrutiny. Emergency stop. Discretion clarified. Officers were now required to treat visible medical distress as a priority override, not a complicating factor. The language was precise, no ambiguity about hazard lights, no room for delayed verification when respiratory failure was present. 2 weeks later came the second reform. Medical override protocols mandated. If a detainee or passenger exhibited signs of hypoxia, seizure, or cardiac compromise, EMS was to be summoned. Immediately lights and sirens authorized regardless of pending verification, warrants, or credential disputes. Scene control no longer outranked life. The third change took longer. Bias interruption training rewritten, not expanded, rewritten. The new curriculum didn't accuse. It confronted. It used footage not just from this case, but from others like it. Moments where discretion narrowed, where doubt tracked differently depending on who was speaking. Officers were taught to pause, to name assumptions internally before acting on them. It wasn't perfect, but it was no longer optional. None of it made headlines the way the arrest had. None of it brought back a child. Months later, on a quiet Monday morning, the judge returned to the courthouse. There was no announcement, no standing ovation, just a calendar cleared and a robe waiting where he had left it. Colleagues nodded as he passed. Some offered condolences again, uncertain whether time had softened the subject or sharpened it. He acknowledged them politely, the way he always had. His stride was slower now, measured. From the bench he listened more than he spoke. When he did speak, his words carried a different gravity, not louder, not harsher, just heavier. As if each sentence had passed through something before reaching the room. In cases involving emergency response, he asked different questions. Not accusatory ones, structural ones. What training had been given? What discretion had been allowed? What policy had failed quietly? Precedent, he knew, was built one decision at a time. At home, the sedan stayed in the driveway longer than it used to. When he did drive it again weeks later, he noticed the passenger seat first. The indentation in the fabric, the forgotten hair tie in the door pocket. He didn't remove it. Justice, when it finally came, hadn't felt like relief. It felt like recognition, late, imperfect, but necessary. It had not erased the night. It had outlined it, given it shape. Forced the system to look at what it preferred to glance past. The officer found work elsewhere, outside law enforcement. The department absorbed the financial loss. The city council debated budgets and reforms. Life, inefficient and relentless, moved forward, but something had shifted. Officers hesitated differently now. Dispatchers coded calls with sharper urgency. Supervisors asked questions they hadn't before, not because they were kinder, but because the cost of certainty had been documented. Silence followed this story, but not the empty kind. It was the kind that lingers after truth has been spoken. There is nothing left to argue on certain nights when the roads were wet and the lights stretched long across the pavement. The judge drove past the exit, where everything had changed. He did not slow down. He did not look back. The passenger seat remained empty. And somewhere between policy and pain, the law at last learned to listen.